Okay, we are back live and we're taking a non-linear break here to talk to Ashlyn Doyen from the Treasurer's Office. And Ashlyn, your title is?
Policy Director. So for the record, Ashlyn Doyen, Policy Director in the Treasurer's Office.
Great, thank you for coming in on short notice. We just wanted to review some of the stuff that we have been talking about since the Treasurer was in last. And one of the things that we have not made a final decision on, but one of the things that we were talking about was we received some testimony from DFR talking about the difficulties that they would have in judging, in particular judging equivalency between a private plan. It's not what they do, they say. And so rather than spell it out in the bill proposal, we're considering just having that fall under rules. Whatever relationship that the division would form with DFR would be done through rules, which has to be done anyway. But generally assign those capabilities to determine that to the division. And I just see as that falls within the Treasurer's purview in this proposal. We just wanted to share that with you as soon as we got the draft this morning and get any thoughts that the office may have on that proposal.
Sure. So the draft that I'm working off of, or that I've reviewed, is Damien's draft from 7:43 p.m. It's 1.1.
That's what we're working.
Okay, great. So this sort of section that you're talking about, I believe starts a little bit later than where you were. And yeah, here we go. Starts on page 27. And so seems as though this proposal asks the Treasurer's Office to do what you had DFR doing in the original bill as introduced. So we would be responsible for reviewing the insurance products that private employers may choose in place of the state plan and determining whether or not those products were appropriate. And then also we would be responsible for the ongoing sort of regulation of those products to make sure that they maintain the provisions that they were accepted under originally. And then if they do not, we would make that determination. If an employer disagreed, we would then also be responsible for that appeals process. So there's certainly a new body of work that this current version asks our office to take on that was not in the bill as introduced. And it's different than anything else that we do in our office currently. So I'll start by saying that if it's the purview of this committee to think that this is the best process and the best way to go about it, we are willing to do it. We don't have a strong objection to these changes in any way. But I think it's just important to talk a little bit about the sort of additional tasks that would be required by our office to do it this way, and to discuss how that's kind of a new concept, right? So the Department of Financial Regulation is already responsible for reviewing and regulating all of the insurance products that are offered in this state. The Treasurer's Office currently does not do anything of the sort. And so in addition to consulting with the Department of Financial Regulation throughout that rules process, and the development of sort of the parameters and metrics that would determine equivalency between private plans and the state's plan, we would probably also need, sort of consulting and actuarial services to help us with that sort of ongoing review as the insurance market landscape changes over time, and we're responsible for continuing to monitor and regulate those plans. And I don't think that that's, I did not listen to Joyce Manchester's testimony this morning, but I understand that she talked about, that will be coming to, as this bill moves through your money committees, the treasurer's office will be coming forward with a plan for staffing and an organizational chart for how we predict that this department would function and the costs associated with that. And so, as we're working to develop that, this sort of new change in the bill does sort of move the target a little bit, and we need to adapt that going forward. But we think that with adequate resources and adequate staffing, that we should be able to. And like was discussed when you were talking about other portions of the bill earlier today, it's an iterative process, developing a program like this. And so there is a 3-year rollout. As we come across things while we're implementing, if there are tweaks or changes or questions that we have for you and ways that we need you to clarify, there's time for us to come back with recommendations on that. So I hope that kind of answers your question. I'm happy to answer more specific questions, but like sort of our general approach to the entire bill is, we're willing to help administer this process, willing to work on it, willing to put in the effort required to stand up a new division. It's just comes down to, will we be adequately resourced in order to do it well? And I think we want to do it well, and you all want us to do it well, so.
And I think you're in a place, as you said, you're in the middle of developing the potential organizational chart, and so you're in a position right now to actually say what that would take, or to at least put an estimate down of what that would take in order to fit, regardless of whether, because we're creating a new division.
Mm-hmm. Right.
So this is the opportunity to do that.
Right, exactly.
Representative Elder?
I know the org chart that Chair Stevens mentioned is part of this, but do you have any broad outlines of what might represent adequate staffing?
Well, the feasibility study from late 2016, early 2017 recommended 47 full-time employees. Other states have more. Some that have implemented this have up to 100. So 47 is on the low end, but again, Vermont's a small state relative to those. We know that we will need the division director, we'll need an attorney, we'll need a business manager, we'll need claims adjudicators, we'll need IT staff, we will need folks that are in the call center and reviewing claims. This sort of adds another little branch to that org chart. We'll need the sort of employer review and insurance product specialist team. And so that's quite a bit. Currently in the treasurer's office, we have 36 staff. We have 14 staff in our retirement division, but the 14 staff in the retirement division are largely customer service oriented. And so the sort of back end components of administering that benefit system happen, in other areas of the treasurer's office. But I just want to echo the treasurer's previous testimony. If this paid family and medical leave program is placed within our office, those departments in the treasurer's office are already at max capacity. We can't ask them to take on more work. And so, business and accounting operations, legal services, that kind of thing will need to be housed within this new division. And so, unfortunately, the treasurer's office is already so lean in terms of staffing that we can't really get efficiencies from the staff that we already have on board. So we think that it will probably at least double the size of our office. It's significant.
And maybe triple.
Maybe.
Maybe what?
Triple.
Of course,
If it goes up to 100, for example.
I don't think it would go up to 100.
We went up to 72.
But you're right. I mean, it's definitely a big change. I will plug, as we're talking about staffing, in our budget request, we requested additional positions in both the retirement division and the treasury operations division. The governor's budget request granted retirement positions, but did not give us treasury operations positions. And so, you know, we will be, when we go in front of your appropriations committee, we'll be making that request again. But if we are tasked with standing up an entirely new division and our leadership team needs to be more focused on that work, we definitely want to make sure that our other divisions that have, you know, current functions and critical functions for the state are shored up and adequately resourced. So we'd hope for your support on that as well. It kind of goes hand in hand.
Well, I think the understanding here is that a new division is not to piggyback on, we're not asking people to start working at 1.5 FTEs, you know, that this is about creating a whole different division, which, you know, so, I mean, the short answer would be yes, this isn't about asking 5 people to double up on their work. This is a lot more substantial than that. I don't think there's any question that it will take that many people to do it. And my understanding is that you will be working on that as this goes through its process. And so by the time the money committees get to see this bill, that there will be as the policy gets locked in, you'll have more to add to the org chart, and you'll be able to present it.
Yes.
Further questions for Ashlyn right now? No, thank you for coming in. We understand that so much of this bill it's to be determined, and that makes it consideration of it hard sometimes, because we like to have more definite outcomes defined. I mean, we know what we know what we want the outcome to be, but we have to appreciate the fact that it comes in steps.
Right. While I'm here, may I comment on another, you have some alternative text in the draft regarding setting the contribution rate and whether or not that is the responsibility of the director of the department or it's a legislative responsibility. I do think that being nimble is really important here, especially in the first couple of years. And so there are a couple of components of the benefit that we're not sure yet how that will translate. We don't have data in terms of how that will translate to pickup rates, right? So example, if you use that expanded definition of close family friend, right, how will that affect your benefit utilization rates? Also, we don't know how many employers will opt to do their own plans. I know you had testimony yesterday that, or maybe it was a comment from a member of the committee who questioned if you have employers that largely employ high income earners and those employers elect to do a private plan versus be in the state plan, how does that affect your projected revenues? So I think just, you know, that's a policy discussion for this committee in terms of who you want to be able to set that rate, at least in the short term. But one of our, you know, primary responsibilities, especially being the treasurer's office, will be to maintain the solvency of the fund. And so having some flexibility in, you know, even if it's within a box of what that rate is as we're looking at the revenues coming in and the benefit pickup rates, could be helpful. I don't know if we have a strong position on it one way or another, but we definitely will be monitoring that fund solvency closely as we get our actual numbers.
As you get your actual numbers.
Yeah. I'm already speaking as though you've officially given us this new division, so.
Well, that's, yeah, I mean, the harsh, not harsh, but the reminder that you said it's gonna be a 2 to 3 year rollout.
Mm-hmm. Right.
You know, we're looking into the future here with some of this stuff, and that's, nobody expected the pandemic, I'll just say that.
Right. Yeah.
We didn't plan for that.
So that's all I have. I'll let you get back to your routine work. Thank you.
Thank you so much for taking the time to come in. All right, Damien, where did we leave? We left off. We got to page 9, safe leave.
Yes. Okay. So the first point within safe leave, bottom of page 9, is the definition of employer. So the question here is really whether you want to phase the rollout of it. So for example, phase 1 would be setting employer size at a 10 or 15 employee threshold to track more closely with the existing Parental and Family Leave Act. And then phase 2 would be to move it to whatever the threshold is for the family and medical leave insurance. So whether that stays at one individual or goes to a different threshold. The other potential option there, the alternative that's not on the page in front of you, is just delaying the effective date on safe leave. But so there's phasing or a delayed effective date. And I think that's for committee discussion.
Yeah, Representative Jane.
I have a preference on this, and I know I've mentioned this before, but if it's feasible, I'd love to see safe leave rolled into our current structure. So I know it's at the 15 and at the 10, so that it becomes an eligible category for now. And then it would already be there when we add the wage replacement and roll in the rest of the program later. So in other words, I'd love to see this granted under our current program now with no delay, so people can take this kind of leave under the current circumstances, and then it'll already be there when we roll out the changes over time.
So the question with that is, would you want it at the parental leave threshold, 10 employees, 30 hours a week, or it's totally doable if the committee wants to go in that direction. That should have been the first piece there. It takes some doing, but I can get that done. Or the other option is to set it, to go back to my original sentence, is to set it at the family leave, so medical care and caring for a family member threshold, which is 15 employees working an average of 30 hours a week.
I wanted the 10.
Okay.
The lowest bar.
The lowest bar, basically, to get this available to the most possible people as quickly as we can. That's just my ref.
Okay. All right, so I'm seeing put this into existing family leave, or?
Yeah, Representative Justin.
Just to clarify, Representative James, you said to get it to most people as quickly as possible, which would be the one.
Well, okay,
But
the
that would
most
be
people as quickly
a
as
lot more
possible in a way that isn't a total nightmare.
Yeah. Okay.
So, in my mind, the +1 definition, we've
Yes.
built a whole bill around when that rolls in.
Mhm.
So I'm okay with that, but I do think we have a way to get this to more people faster without rewriting the entire bill.
Okay.
And, we may hear from the representatives from the network at some point, but with their thoughts on that. But that was just, for the time being, so Damien, that's a separate definition of employer. And then does this is what makes it weird, right? Because this is new. But the definition of employer in the next section, which will be the family medical leave insurance and the FLA section, actually says employer is anyone with an employee. The but is way back at effective dates. So if this is drawn in as 10 or 15 employees, does that definition of employer change this automatically? Because this would take place immediately.
So what you're gonna see is, instead of sections 1, 2, and 3, the current sections 1 and 2 are gonna become sections 3 and 4. New sections 1 and 2 are going to be the existing Parental and Family Leave Act with the addition of safe leave at that 10 employee threshold. So you'll see a change to existing law that takes effect July 1 or whatever date you set. You'll see a change to the law then being future dated for October 1, 2026 or whatever date you set. So it would take effect with the ability to take benefits. So that's what you'll see in this bill. So it'll be 2 new sections that incorporate the safe leave. The bill will get a little bit longer, but a lot of the language in the safe leave section is duplicative of language that's in the current PFLA law. And so it's really going to be changing definitions and then just adding language to coordinate throughout. And then I'll have to do some updating in the new paid leave law just to reflect that safe leave is encompassed within the family leave definition. So, but it's doable.
And does the more comprehensive shift in the definition of employer, does that happen in 2026?
October 1, 2026 under the current bill.
Doesn't happen when contributions begin, it happens when benefits.
So the change to the job protection definition of employer is October 1, 2026, because that's when people can start taking leave. The change for paying purposes of withholding and paying contributions is going to occur 15 months before that. Because that's when, or really it'll occur on July 1 of this year, because they'll be starting the draft regulations off of that. We're just not doing tax contributions until that date on July 1, 2025. So does that make sense? So benefits, so paid leave benefits, definition of employer is going to change right away so that they can build out the program and then start collecting taxes mid-2025. Job protection, definition of employer will not change until late 2026 because that's when people will actually be able to use those benefits. Okay. So changing it before then, there's no reason to because there's no benefit program to line up with.
Okay. Yep.
Makes sense? Okay. Good. I couldn't think of an analogy, so, and that's usually my go-to. So I appreciate that. Other questions?
Yeah, if you can just untie it for us and then. Okay.
All right.
The next change from there was in subsection B.
Yep. I can delete this one actually because of what you just discussed. So, so with the phased in implementation of this as part of PFLA, you don't need to worry about delaying the effective date. Oh, yeah, you don't. because this is going to be in the phased language with PFLA. It already is.
Yeah.
So that, okay, we're good.
Chair Santangelo.
I just want to make sure on page 9 where we're talking about going with 10 employees and holding off, is that a decision or is that another draft committee decision?
Well, it is a policy decision. Is it an easy policy decision? Can people go thumbs up or nods up, or do we need to discuss this further? Perhaps if we hear from an advocate or something like this, is this something that we want to keep open for conversation?
So one thing that's worth noting is if you change the next draft to go with the new policy direction that's being proposed, because I already have one draft saved with the old policy direction, it's not terribly hard for me to go back and just pull those chunks out and put them back into the new draft, and then just go through and make sure I've made the other changes necessary. So I can go back to version 1 and put that back in for version 3. Wouldn't be the first time that's happened to me. So,
I mean, based on the conversation I heard, I didn't hear any agreement. We heard a conversation about 10 employees and having safe leave be added to PFLA July 1 with employers who have 10 or more. And then it would change to the +1 in 2026. Is that reasonable to move forward with? I mean, is that acceptable? I can hear consensus, but in general, but
So, excuse me.
Yeah.
This would then have to go to appropriations to recalculate if you're gonna add these people on July 1st. The funding hasn't been agreed upon.
no, this is for the job protection piece. This would be under the unpaid leave section. And so I'm not sure what appropriation it would affect. This would be creating more people who are covered under the unpaid leave, the Vermont unpaid leave.
yeah, so a couple things. So there will be, this will affect the fiscal note, because there may be some short-term leave costs to the state in terms of under their current leave policies, having to expand those to cover safe leave. So there may be some short-term changes related to that. For the program startup costs, this isn't going to change anything, because these folks were already coming into the program on the benefits end. And what this is doing is, instead of saying on July 1 that every employer in the state is required to provide job protected safe leave, it's saying just employers with 10 or more employees who work an average of 30 hours a week will have to do it, which will affect the state a little bit, but it delays the onset of this for smaller businesses for having to provide the job protection. It's not going to affect the bottom line for the program. Presumably, Patrick may have to make some calculations as to whether there will be any effect on state payroll. I don't know if there would, because right now your options are to use your accrued paid leave. And so I don't know what impact, if any, there would be on the state's payroll, which is what the fiscal note would look at, but JFO can figure that out. The effect is going to be there either way under both the current version and the other one, because the state will be above the employer threshold in both of those. So, yeah.
Yes.
Thank you. This is just kind of a memory from last year, and want to make sure it's our intent. Or Joe Benning coming out. In page 10, the member is a victim of. Are we intending that the case has been settled?
That is a very good question. I think, yeah, you adding the word alleged victim. A victim or alleged victim is actually probably better. So because you don't want it to be, well, your case has been settled, you're no longer entitled to the leave to deal with it. So be alleged victim or victim. And that's because that would cover someone who's just, had a criminal complaint filed, but the trial is in 9 months or a year or something like that.
Because, we're including, relocating to safe housing, things like that. Which also just brings up, and if we make that change, do we want to say that if, you take your 12 weeks of job protected leave and your case is settled, the person's found guilty, where you're not. Like, so.
Yeah, so, so this is up to 12 weeks of leave in a 12-month period. When it's included under PFLA, it means that this combined with anything else that you have to take leave for that's under that. So your leave caps at 12 weeks in a 12-month period. When the 12-month period finishes, or when you get to a point where doing the 12-month look back, some of that leave has dropped off, you'll be able to take additional leave. So for example, if you took 6 weeks of leave related to recovering from injuries and relocating, and then the trial occurs, 12 months later, and because of what happens at trial, maybe you need to take further actions and I'm not sure what that would include. We have a separate job protected leave provision for going to trial. That was what Joe Benning had introduced the bill to revise last year. And then, but then if there's another reason to take it at that point, if you've gotten to the point where you have, you potentially have another 6 weeks to take in the remainder of that 12-month period. And then once you get past 12 months from the original 6 weeks of leave, you've got your full 12 weeks again, if you need it. So if you had a child, if you had a serious injury, something like that.
It's just one of those, another can of worms would be that if it's changed to, if we do intend to change it to alleged, and, 4 months later, court decides it was actually a pretty mutual fight you two had, and you're both victims and you're both at fault. I don't remember if it was this section. Was it the other section that said you would be the?
It was later, and I don't have an answer on that yet.
Be the, I don't know where to use.
If you're the perpetrator.
Yes.
Yeah, so I think it's at the time that the claim is made that you're making the determination, and if it's later determined that you're no longer eligible, then at that point your eligibility would cease. But you're looking in real time. So for example, I'm trying to think. If your timeline for recovery from a serious injury changes and you no longer need the leave for the serious injury, you can come back to work early, assuming you're cleared to work. Same thing. It's kind of the same thing as with sick leave. If you're no longer sick, you're no longer eligible to use the leave. From an employer's standpoint, a lot of times you don't have that information. If for example, the individual recovers a week early, you may not know, and they use their leave or they don't, and you've approved it. The way our law is phrased, it's up to the employer to decide whether the employee can come back early, because sometimes you sign a temporary contract with another employee and you don't want to have both of them on payroll. But yeah, under this, I think if it was later determined that you're not eligible, the employer could say we're not providing you with additional leave at this point.
But would the provider, or would the company be able to, say, recoup any insurance coverages they were providing you during that leave, protected leave? Anything like that, if it turns out that you were the perpetrator?
I think it's an issue of whether it was a fraudulent claim at that point. So if it's a fraudulent claim, then you've got insurance fraud. And so at that point, the insurer likely would, if it's enough money, would want to go after the money to recoup it. If it's the state, there are provisions for that if it's a fraudulent claim. I think if the claim is made in good faith, and not made fraudulently where there's a misrepresentation, an intentional misrepresentation of the facts, then I think there's likely to be less basis to recoup that money. So a lot of it's going to be pretty fact specific. But if you have an instance where someone fraudulently alleges that they're the victim of domestic violence and say they forge documentation or something like that to get the 12 weeks of leave, if that evidence comes to light, then the insurer, if the company goes that route, or the state could go after them to recoup the funds for basically fraudulent activity. And then, I mean, when you get into insurance fraud, there's additional penalties for insurance fraud if it's, shown to be part of a criminal scheme or something like that. But that's getting out of my area of expertise.
I'm not even really thinking about the whole fraud aspect.
But that's kind of your avenue. As an employer, I think if you discovered on week 4 of a 12-week leave that the claim was fraudulent, at that point you could terminate the employee, and they could fight the termination, but you'd have a basis of saying that you were being provided leave under a claim that turned out to be based on forged documentation or something like that. Same as if someone claimed a PFLA leave now with a forged doctor's note, and you later discovered that they had forged the note. So I think at that point you lose the protection.
Okay.
So,
all right, so back to we're up to page 11 now, because we deleted 1 and 5.
Yep. The next discussion was the minimum increment for safe leave. If we're moving this into the existing leave law, I believe that there's already language in there.
So you can put out number 2 altogether.
Yeah, I think we can shortcut that, assuming you don't want to change the existing law.
Committee, thoughts?
What's the existing language?
Let's just see.
Okay.
There is not existing language, presumably because we don't require payment. The sick leave law requires it in the smallest increment that the employer's payroll system handles. But we could also, if we bring it into the existing Parental and Family Leave Act law, because it's unpaid safe leave, we could stay silent on it and let that be determined by employer policy. We could add in language that says, leave shall be paid, that just tracks the sick leave, saying that use of accrued paid leave shall be done in the smallest increment that the employer's payroll system handles. And I think we we put a cutoff of like 1/10 of an hour or something in there. Which I can't remember what it was, but I could put that language in if the committee wants to look at it. Or I could just be silent on it since we're bringing it into the existing law and it's not there. Thoughts?
Any thoughts on that?
It seems to me that if we're talking about ultimately a 12, up to 12-week program, talking about hours is too granular, yeah. And I think that
Yeah, I
a
mean,
day,
okay. So, I mean, right now, so Representative LaBounty brought up the instance right now, if you were to have to undergo an hour of radiation treatment every day, your employer is required under law, assuming you're covered, to provide you with the leave for that 1 hour a day. And travel time and whatever else. But, you know, so that could be at 2 or 3 hours a day where they're just paying out 2 or 3 hours a day of accrued paid leave, assuming you have it. So that, I guess that's just the thing to keep in mind is right now.
you would still have the option, right? You could do paid family leave insurance, or you could do sick time.
Yeah, so paid family leave insurance, when it comes into play, will be in a day at a time.
Yeah.
And if we stay silent on the safe leave under the existing law, I think it's just the increment that you use it. So if it's an hour and a half to consult with an attorney or to see a doctor for a follow-up visit versus if it's a week off to relocate, you know, it would just depend on the instance. And I would defer to the advocates, you know, as to whether they think that's appropriate or not, but that is one option, is just to stay silent. And I would expect it to continue tracking existing law, where if you're permitted to use accrued leave and you do it and it's a covered leave, then you get to use your accrued leave for that covered leave if the employer's not gonna pay you. So, does that make sense? Okay, so
So what did we decide?
I think, am I seeing not adding language at this point? Just leave it under the existing?
Yes.
Okay. Okay.
All right, last change, because we have to stop at 5:00.
This change here was just that technical error that had been brought to my attention last weekend. And this clarifies that you can use accrued leave, family and medical insurance benefits, and short-term disability. The language is already in 472, so we don't need to discuss it further unless someone sees a problem.
How does this,
The
how does the extended leave provision that we have for safe leave, that people can take up to 12 weeks more of job protected leave, fit with that statement?
So, if you bring the safe leave into PFLA and you just made it another type of leave covered, you'd have 12 weeks across the year for whatever type you take, whether it's parental, safe leave, or family or medical leave. If you leave safe leave separate as 472D, right now the way it's worded is that this leave is in addition to any other leave provided. So then you could be 12 weeks of parental or family or medical and 12 weeks of safe leave.
Right.
Assuming you had a need.
And if we roll this into the existing section, would we be able to write in for the purposes of safe leave only?
Yep. So it's not unheard of in other states to say that, particularly around parental leave, if there are complications during the pregnancy or childbirth, to add an additional 4 weeks. So that's something you could say for the purposes of, same thing you could say for safe leave, you could say for purposes of safe leave only, an employee shall be entitled to an additional 4 weeks of safe leave if they have exhausted their leave allowance pursuant to this
I'd
section.
like to keep the 12 weeks.
An additional 12?
weeks. I mean,
Okay.
I'd like to propose just keeping it the way that it's been proposed in the bill is introduced, but if we're moving it into the other section, I'd like to have that taken care of.
Okay,
Right. Is that okay for folks? Okay, let us be done for the morning. There's lots of pages coming up with notes, so